Welcome to Module 22, Consumer Protection. Consumer protection is a very important compliance area. There are a lot of laws around consumer protection, and there are a lot of penalties for violating those laws. And since 2010, we've also had the Consumer Financial Protection Bureau, which has very much brought increased attention to consumer protection in banking and particularly in credit and other related areas. So the main statute that we're talking about today is the Truth in Lending Act, which was enacted in 1968. You might notice many of these consumer protection statutes at the federal level were enacted in 1968, 69, 70, that time period. Prior to this period, a lot of consumer protection was at the state level and on a state-by-state basis, particularly in regard to credit. So it was decided that consumers needed better information. Now, because we always have a balance of state and federal regulation to consider, the idea was that credit would continue to be regulated on the state level, and it would only be disclosures. So the Truth in Lending was only a disclosure statute when it was enacted in 1968. It had two parts: open end and closed end, and it had an implementing regulation, Regulation Z, and that continues today. The biggest change was when Regulation Z was moved from the Federal Reserve Board's oversight to the Consumer Financial Protection Bureau's oversight. But the whole goal of the original Truth in Lending Act, or TILA, was to give people information so that they could make good decisions and they could shop for credit. So the first thing to look at, and hopefully you've learned this in the course of the semester, is the definitions. Who does TILA apply to? It applies to creditors who are defined as those who regularly extend consumer credit, note, subject to a finance charge or payable by written agreement in more than 4 installments, and to whom the obligation is initially payable. So if you think that through, one, you realize very quickly it's not just banks, although it definitely includes banks. What it doesn't include are those pay in 4 that you see all the time now being offered on retailer websites. But what it does include are agreements such as what an orthodontist might offer if they allow someone to pay the price of, say, braces over 12 months. And so it has very far-reaching consequences. But you must trigger the definitions for it to apply. And another part of that is that it is consumer credit, which is credit extended primarily for personal, family, or household purposes. And as we saw in our reading for this module, it's not always clear. And in the real world, it's not always clear. So the idea at the time was that consumers are less sophisticated and they also have less bargaining power. But there is somewhat of a belief now that that is also true of many small businesses, particularly sole proprietors, or in today's economy where people are working as an Uber driver or selling things that they make out of their home. There's a kind of a unclear line. So it is not always as easy to guess. And as a compliance professional, you have to make it, the right disclosures. And so we do see some erring on the side of caution. It does exempt business, commercial, agricultural, organizational credit, although, like I said, business versus consumer is not always black and white. And we are starting to see the states enact commercial credit disclosures. Specifically, New York and California have both enacted commercial disclosure statutes. The original TILA was divided into the open-end part and the closed-end part because, as we'll discuss, those are very different types of credit factually, so it is required that the disclosures be quite different. We now see that TILA is greatly expanded, and we have additional provisions applicable to credit cards and student loans and mortgage loans. But the open-end, closed-end credit provisions still apply in addition to sometimes additional provisions. So closed-end credit is credit other than open-end, and super helpful definition. And then open-end is credit in which the creditor reasonably contemplates repeated transactions. The creditor may impose a finance charge from time to time on the outstanding balance, and the amount of credit is generally made available to the extent the outstanding balance is repaid. Well, 2 and 3 are written in the may, so it's really the first one that is the key. Reasonably contemplates repeated transactions. Again, not always as easy as it might seem. And in today's world, I find a lot of products where there's a lot of discussion over whether it's truly opened or closed end. So kind of the first step in determining how to comply is determining what category product falls into. The most important disclosure, at least for closed end, is the finance charge, because this is designed to disclose the cost of credit. And the finance charge, somewhat like what we saw with interest and preemption, is the cost of consumer credit, and not just a percentage or the interest. And it includes any charge payable directly or indirectly by the consumer and imposed directly or indirectly by the creditor as an incident to or a condition of an extension of credit. It does not include charges that are payable in cash transactions. So that is one clear exclusion. But as you hopefully saw from the cases, there are times when creditors make the wrong choice, and that's a TILA violation, which can quickly result in a lawsuit. The regulation gives some examples to help you. Interest, that's part of the finance charge, service, transaction and carrying charges, points, loan fees, assumption fees, all part of the finance charge. But what we see are not included, which is sometimes arbitrary, but application fees, if they're charged to all applicants. Not very common now, but you used to see an application fee being common, and that would be paid whether you were approved or not. Late fees and NSF fees, because those are, again, unanticipated and unavoidable. And fees to participate in a credit plan are also excluded. So again, it's a statutory area where you need to really look at the regulation and try to figure out where a charge you intend to charge falls. So we'll look first at the close-end disclosures, and those are listed in the regulation. Some are pretty clear and they may be familiar to you if you've taken out credit. Of course, you need to name the creditor, the amount financed, more or less what you're borrowing, the itemization of that amount, the finance charge, a key disclosure, explanations of a variable rate, a payment schedule, which includes a total of payment. If it's a finance sale, there's the total sale price, prepayment, late payment, and security interest charges and references, and a contract reference. So here's the model form out of the regulation. I apologize, it's blurry, but it is actually blurry in the regulation. You can look it up. It's 12 CFR part 1026, and it's Appendix H. This is the second model form. And one of the things to know is that the regulation is very specific on how this is laid out and presented. And in fact, the fact that annual percentage rate and finance charge are capitalized is part of the requirement that those two be more prominent. Here's an example of one a bit easier to read, but again, you see the prominence of those two boxes. You see the payment schedule, you see the late fee, the prepayment fee, the contract reference at the bottom. What you also see here is what you're borrowing per se, the amount financed, the finance charge, basically what you're paying for that, and then through a mathematical calculation, you get the interest rate, which in this case is 11.88%. Now, I'll tell you that this is a loan at 10% interest, but because there's a loan fee that goes into the finance charge, the interest rate for this one-year loan is 11.88%. And that is somewhat explained by the amount financed that then appears under that table, where you see that the person is receiving $10,000, but they pay a $100 fee. So really what they're borrowing is $10,100, but the $100 is a prepaid finance charge. So it goes in the finance charge box, and the amount financed is the $10,000. So this all lays out very clearly exactly what you're going to pay on this closed-end transaction, what you're getting, exactly what you're going to pay, assuming you make all your payments on time. And that is assumption you're permitted to make because the disclosures are given on day one with the assumption that everything is done as agreed. Closed-end is quite a bit different. You see a listing of all the items that must be disclosed, basically the annual percentage rate and all the potential fees. Here is the model form, and it's also in the appendix. But what we see is this is more a table of potential charges. You see your annual percentage rate. This one has a balance transfer and a cash advance APR that are different, happens to be variable. This one has a penalty rate, talks about paying interest. That's prescribed by regulation, that language, the minimum interest charge, the contract reference of how to look up for more information. Then you see all the fees that are charged, some of which are set amounts, and some of which can vary. So it's really just giving you a sense of what you might pay. So when you look at these, what you probably see is that in the closed-end situation, you very quickly are faced with exactly what this credit is costing you. And on the open-end side, you're just basically faced with the rules. And because of that, there are times when creditors prefer this. It's an easier disclosure to give because it's not personalized, and it can be less alarming to the borrower. So that brings us to our first case on page 858, where Benyon sued Bank One, which I don't know if any of you remember, but was a very big bank in Columbus, Ohio, that is no longer existing. This was a satellite dish buyer. You see satellite dish buyers and mobile home buyers bringing a lot of suits. In part because something to remember, and all compliance professionals probably know this, at least consumer compliance professionals, is that unhappy customers bring lawsuits and contact regulators. And so if someone is unhappy with their purchase, which appears to happen often with satellite dishes, oftentimes the financing is the easiest way to get to court because the rules are very strict. And if you don't follow them, you violated the law. So these people were not happy with the satellite dish, and they end up bringing a class action against Bank One, saying that you gave us credit card disclosures, very vague, and this should have been a closed-end disclosure. We bought a $3,000 satellite dish. We spent $1,000 for programming, and you said this was a credit card when we only had $4,500 for our credit limit. Something to keep in mind is that in the consumer context, it is almost always ripe for class action. If Bank One did this to the Benyons, this is what everyone was getting. So that is another reason that compliance in this area is so important, because if there's a lawsuit, it's almost always going to be brought as a class action. So the question before the court is, was this really open-end credit? Because if it was, everything's fine. But if it wasn't, they gave the wrong disclosures, they violated the law. And as we'll see in the next module, there's a series of penalties that will apply. Well, the court looked at the standard, which is that the creditor contemplates repeat transactions. And they said, we think Bank One does. There was $500. Some people did, maybe not a lot, but everyone could. And that was what the creditor contemplated. And this continues to be the standard today. Does the creditor reasonably contemplate repeat transactions? So it's a bit of a vague standard, but it is what we have. And what's important is that you make the right decision and that the contracts support the decision that the creditor makes and that the right disclosures are there then given. So after this time, the prevalence of credit cards greatly increased. And at the same time, the complaints greatly increased. And ultimately, in 2009, there was the CARD Act, and it had a series of provisions that apply only to credit card. And that's something I referred to early on in this module, that there is now an entire section of TILA that's enacted in 2009, and now in the Regulation Z, that deals just with credit cards and the abuses that were testified to in Congress. And one has to do with these APR increases, and that the APR should not increase in the first year unless it was advertised as a 6-month promotional rate, unless the credit card holder is 60 days late, and then they can get into a default situation with a default interest rate. It also restricted over-limit fees and requires an opt-in. As we know, opt-ins are very difficult to get, and has basically resulted in the elimination of over-limit fees. A lot of consumers testify that they went to buy something, it went through, then they find out they got an over-limit fee, and they assume that if they hit their credit limit, they just get rejected. So now creditors have to ask people, do you want us to run the transaction and charge you a fee? Well, creditors decided nobody wants that question, and so they just did away with over-limit fees. It also, in the Card Act, increased the notice for increases in APR or other significant changes, which are largely increases in pricing. And it requires this notice laid out in a very clear format put forth in the regulation, and the ability of the cardholder to close the account and pay off under the existing terms. And so there's a series of other changes that are discussed in your book, but probably one of the most significant was the restriction on penalty fees. It's been a big topic for quite some time. We've read some early cases on that in the context of the preemption. And so as part of the Card Act, into TILA was put something that said these fees, late fees and NSF fees, must be reasonable and proportional to the cost incurred by the issuer. There's a very complicated way to determine this. But it also put in a safe harbor. The safe harbor was subject to adjustment based on the consumer price index, but it's currently $30 for the first late payment and then $41. And that is really what everyone went with. The calculation was really unworkable. I don't know any bank that uses that. And that's how it's been until now. In 2023, the CFPB, along with the White House, started talking a lot about junk fees, and it included late fee and NSF fees in this category. I don't know if that's exactly true because they are all contracted for, unlike those Ticketmaster fees, but nonetheless, the CFPB has proposed reducing the permitted late fee to $8 or 25% of the required minimum periodic payment. Needless to say, that would be very, very small. This proposal could be adopted any day, and I'm quite certain that when that occurs, a lawsuit will immediately be filed. So we can keep an eye on that and discuss it in the discussion if it has occurred. So these are all some specific credit card provisions. There are also some provisions that relate to the charging, because as you can imagine, at this time, credit cards are just emerging. So there are liability issues. And one of them is the Fair Credit Billing provision that applies to all open-end credit. And essentially, it provides that a customer has 60 days from getting the statement to dispute a charge. And the creditor then has 30 days from receiving that notice to acknowledge receipt of the dispute, and then it has 2 billing cycles to investigate and make a determination. And during that period, the consumer cannot be required to pay the disputed amount or any finance charges that relate to that amount. And so this was sort of a fairness issue. There was a concern that consumers would not have an appropriate redress, and so this was put into TILA. Now, this leads us to another case that we read, which is the American Express case that brings up the issue as to, is something consumer or business credit? Because this was a business credit card, but this individual was a consumer and used it for some personal purposes. And they had disputed some charges, and it's clear here that American Express had not complied with the TILA time limits and how you deal with a dispute. But their position is it's a business credit card. So if it's a business credit card, they've done nothing wrong. If it's a consumer credit card, they violated TILA. And as we'll find out, there are statutory damages. What the court looks at, and really what they typically do, is the contract. The contract between the parties indicated this was a business credit card, and so it's determined that American Express has done nothing wrong. Now, if it appears that there was some kind of an attempt to evade TILA by giving everyone a business credit card, I don't think that would withstand, but in the absence of some kind of fraud, typically the contract will control. So the next type of protection we see has to do with unauthorized payments. And actually, I'm sorry, these are unauthorized charges, not payments. It's not wanting to pay for an unauthorized charge. So in this case, the cardholder said, these aren't my charges, these are unauthorized, and so they didn't pay them, and then the card issuer sued. The cardholder counterclaimed and said, hey, I don't have to pay. And, you shouldn't be suing me for these items. And at this time, the statute provided that there was no more than $50 liability on the part of the cardholder, and that was only if these charges occurred before the notice, provided these steps were taken by both the card holder as far as notification and the card issuer as far as how to notify. And what is important to keep in mind here is that at this point, there's really not the internet. So 1976, there's just the real card. So if there's unauthorized charges, that card has been stolen. So Congress had to decide, where should the burden lie? The cardholder presumably has done nothing wrong. The bank's done nothing wrong. But here is a bad actor. Who bears that risk? And essentially, it was put on the bank as the one best able to prevent this. And so now what we see, and I think it's a good thing, is that the cardholders have very, very sophisticated procedures for preventing unauthorized charges. And the law has been changed some just to account for today's situation, but the liability of a cardholder shall not exceed the lesser of $50 or the amount of property, goods, or services obtained before notification. An unauthorized charge is a charge that was made without the actual implied or apparent authority of the cardholder and for which the cardholder received no benefit. Now, as the case mentions, there can be some room for fraud if the cardholder is a bad actor, but the assumption is that the cardholder is not a bad actor, and that as between the two parties, the card issuer, who now has sophisticated programs, is the best one to be able to stop these unauthorized charges. And as you might be aware, all of the card issuing agencies, the Visa, MasterCard, Discover, and American Express, have actually extended zero liability. But under the law, they could charge the cardholder for $50 prior to notice. Of course, now that we're not talking about a card being stolen, we're actually talking about the number being stolen electronically. It's very unlikely that a cardholder would know until the charge actually occurs, which is probably why the card issuing agencies have determined that zero liability is really more appropriate. So what we see is that TILA and Regulation Z provide a lot of very specific requirements on the banks and a lot of timing and liability issues that benefit the consumer. In our next module, we'll talk a bit more about remedies, and it will give you a good sense of why some of these suits are brought and how sometimes the remedies are really what drives maybe compliance, or at least drives the lawsuits. So please let me know if you have questions. Thank you.